2 days ago, the Supreme Court heard oral arguments in a case that could free millions of Americans from federal gun prohibitions. The case is United States versus Hemani, and it's about whether the government can permanently strip gun rights from people who use illegal drugs. The oral arguments happened on March 2nd, 2026. For 2 hours, the justices grilled both sides. They asked about historical tradition. They asked about Bruin. They asked whether someone who smoked marijuana once should lose their Second Amendment rights forever. And based on those arguments, we can predict how the court will rule. This is breaking news. The decision won't come until June. But the oral arguments tell us everything we need to know, and what they tell us is the government is in trouble. The justices are skeptical, and this ban might not survive. If you use marijuana, even in a legal state, this case determines whether you can keep your guns or lose them forever. And you need to understand what just happened at the Supreme Court. Quick question before we continue. Are you subscribed yet? Because what I am about to reveal is real-time analysis of Supreme Court oral arguments that happened 48 hours ago. The justices' questions and comments signal how they'll rule, and that ruling will affect millions of gun owners. Hit that subscribe button right now, because when the decision comes down in June, you need to understand what it means immediately. Here's what happened and what it means. The case is United States versus Hemani. Hemani is a man who was convicted of possessing a firearm while being an unlawful user of a controlled substance. The law is 18 U.S.C. section 922G(3). It says if you're an unlawful user of marijuana, cocaine, heroin, or any other controlled substance, you cannot possess firearms. It's a federal felony. Up to 10 years in prison. Hemani challenged his conviction. He argued the law violates the Second Amendment. The district court agreed and dismissed his case. But the government appealed. The case went to the 11th Circuit. The 11th Circuit sided with the government and reversed. Hemani appealed to the Supreme Court, and the court agreed to hear the case. That's significant. The court only takes about 70 cases per year. If they took this one, it's because they think the issue is important, and the lower courts might be getting it wrong. Oral arguments happened on March 2nd, 2026. The government was represented by the Solicitor General. Hemani was represented by a top appellate lawyer backed by gun rights organizations. Each side got 1 hour to argue, and the justices asked tough questions. Let me break down what happened, because the questions reveal how the justices are thinking. The Solicitor General opened by arguing, the government has always had the power to disarm dangerous people. Drug users are dangerous because drugs impair judgment. Historical laws against public drunkenness show governments regulated intoxication and guns. So the drug user gun ban has historical roots. Chief Justice Roberts interrupted. He said, but those historical laws were about being drunk in public while armed, not about permanent disarmament for private drug use. How is this law similar? The Solicitor General said the principle is the same. Governments kept guns away from impaired people. Roberts pushed back. He said the historical laws were temporary and targeted at conduct, not status. You were arrested for being drunk in public with a gun. You weren't banned from owning guns forever just because you drank alcohol sometimes. That's a big difference. Justice Thomas asked about marijuana specifically. He said marijuana is legal in many states now. How can the federal government ban gun possession based on conduct that's legal under state law? The Solicitor General said federal law controls. Marijuana is a schedule, a controlled substance federally. State legalization doesn't change that. Thomas didn't seem satisfied. He pressed further. He asked, what if someone used marijuana once 6 months ago? Are they a user under this law? The Solicitor General said it depends. The ATF looks at whether the use is current and regular. Thomas said, so the law is vague? The government can't define when someone crosses the line into being a prohibited person. That's a due process problem. The Solicitor General tried to defend the ATF's guidance, but Thomas cut him off. He said, guidance is not law. Congress wrote the statute. And the statute doesn't define unlawful user clearly. That's unconstitutional vagueness. Justice Alito asked about historical tradition. He said, under Bruin, gun regulations need historical analogs. What's the analog for this law? The Solicitor General pointed to colonial laws against giving guns to people deemed dangerous. Alito said, but those laws required a finding by a magistrate that someone was dangerous. This law just declares an entire class of people prohibited based on self-reported conduct. Where's the historical analog for that? The Solicitor General struggled to answer. He said the principle of disarming dangerous people is historical. The specifics might differ, but the principle is the same. Alito didn't buy it. He said Bruin requires more than general principles. You need actual historical laws that are relevantly similar, and you don't have them. Justice Kavanaugh jumped in. He asked, what about people who used drugs years ago but don't anymore? Are they permanently banned? The Solicitor General said no, the law only applies to current users. Kavanaugh said, but current is undefined. How long do you have to abstain before you're no longer a user? The Solicitor General said it's a fact-specific inquiry. Kavanaugh said, that's exactly the problem. People don't know where the line is. How can they obey a law they can't understand? If you're finding this helpful so far, imagine what you'll learn in my next video, where I break down every justice's voting pattern on Second Amendment cases and predict the final vote count in Hemani. Subscribe right now so you don't miss it. Now let's talk about Hemani's lawyer's argument because it was strong. The lawyer opened by saying, the Second Amendment protects the right to keep and bear arms. That right belongs to the people. Drug users are people. They don't lose their constitutional rights just because they use substances. Historically, governments did not permanently disarm people for substance use. There were laws against public drunkenness, but those were temporary. Once you sobered up, you got your rights back. This law is different. It strips gun rights based on status, not conduct. And it does so without due process. There's no hearing, no finding that you're dangerous. You just check a box on a form saying you use drugs and you're banned. That's unconstitutional, Justice Jackson asked. But don't we have an interest in keeping guns away from impaired people? The lawyer said yes, but this law doesn't do that. It bans gun possession by people who use drugs, even when they're sober, even in the privacy of their homes, even when the drug use is legal under state law. The law is vastly overbroad. Jackson asked, so what's the alternative? Do we just let drug users have guns and hope for the best? The lawyer said no, the government can criminalize being intoxicated while possessing a gun. That's a narrow, conduct-based restriction with historical roots. But you can't ban an entire class of people from owning guns based on private behavior. That's a status-based ban with no historical precedent. Justice Barrett asked about Bruin. She said, the government argues there's a historical tradition of disarming dangerous people. Doesn't that satisfy Bruin? The lawyer said no, because the historical laws were targeted and procedural. You had to be adjudicated dangerous by a court. This law doesn't require that. It's a blanket ban on anyone who self-reports drug use. That's not analogous to historical laws. Justice Gorsuch asked the toughest question of the day. He said, the government talks about historical principles, but Bruin says we need historical laws, not principles. So where are the laws? Show me a founding-era statute that permanently banned gun ownership for alcohol users, or opium users, or any substance users. The Solicitor General, who was still at the lectern for rebuttal, admitted there are no exact matches. Gorsuch said, then you lose under Bruin. It's that simple. The Solicitor General tried to argue that the founding era didn't have the same drug problems we have today, so we can't expect identical laws. Gorsuch said, that's not how Bruin works. The whole point of Bruin is, you can't justify modern gun control by saying times have changed. You need historical tradition. And you don't have it. That exchange was devastating for the government. Gorsuch is one of the most textualist justices. If he's convinced the law lacks historical foundation, he'll vote to strike it down. And he seemed convinced. Now, quick legal note. This is educational information based on oral arguments, not legal advice. The Supreme Court hasn't ruled yet. The law is still in effect. If you use drugs and possess guns, you're violating federal law. Do not assume the law will be struck down. Wait for the actual decision. Consult with an attorney about your specific situation. Now let's talk about what the oral arguments tell us about the likely outcome. Based on the questions and the tone, here's my prediction. The court will strike down the drug user gun ban, at least in part. The vote will probably be 6-3 or 7-2. The majority will be the conservative justices, plus possibly 1 or 2 liberals. Chief Justice Roberts, Justice Thomas, Justice Alito, Justice Gorsuch, Justice Kavanaugh, and Justice Barrett all seemed skeptical of the government's position. They questioned whether the law has historical roots. They questioned whether it's too broad. They questioned whether it's vague. Those are all signals they'll vote to strike it down. Justice Sotomayor and Justice Kagan seem more sympathetic to the government. They asked questions about public safety and the dangers of drugs, but even they didn't seem fully convinced. Justice Jackson was harder to read. She asked tough questions of both sides. She could go either way. So my prediction is 6-3 or 7-2 to strike down the law. But the opinion will be narrow. The court won't say drug users can never be prohibited from guns. They'll say this law is unconstitutional because it's overbroad and lacks due process. The government can pass a narrower law, maybe one that requires a court finding of dangerousness, or one that only applies when someone is actually intoxicated. But a blanket ban based on status? That's gone. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now let's talk about what this means in practice. If the court strikes down 922 G3, millions of Americans get their gun rights back. People who use marijuana in legal states. People who used drugs years ago but are clean now. People who were banned based on a vague standard they didn't understand. All of them would no longer be prohibited persons. They could buy guns. They could keep the guns they have. Form 4473 would have to be revised. Question 21E, the one about drug use, would probably be eliminated or rewritten. Dealers wouldn't ask about drug use anymore. The ATF would have to stop enforcing this provision. It would be a massive change. But here's the catch. The court might not go that far. They might strike down the law as applied to Hemani specifically without invalidating the entire statute. Or they might say the law is unconstitutional for marijuana users in legal states, but still valid for users of harder drugs like heroin or meth. We won't know until we read the opinion. Let me give you a real-world example. Imagine a guy named Dave. Dave lives in Colorado. He uses marijuana recreationally. It's legal under state law. Dave also owns guns. He's been violating federal law for years. He knows it. But he's never been prosecuted. If the Supreme Court strikes down 922G3, Dave is free. He can keep using marijuana and keep his guns without fear. But if the court upholds the law, Dave is still at risk. He's still violating federal law. The ATF could prosecute him at any time. Dave is watching this case closely. Now imagine a different scenario. Imagine a woman named Lisa. Lisa used cocaine 5 years ago. She got clean. She's been sober ever since. But when she tried to buy a gun last year, she truthfully answered yes to the drug use question on Form 4473. The dealer refused the sale. Lisa feels like she's being punished forever for past mistakes. If the Supreme Court strikes down 922G3, Lisa can try again. She's no longer a prohibited person. But if the court upholds the law, Lisa is stuck. She lost her gun rights because she was honest on a form. This information could determine whether you get your gun rights back or stay prohibited forever. Subscribe now because my next video will analyze the actual Supreme Court opinion the day it comes out in June. Hit that subscribe button. Now let's talk about the timeline. The decision will come down in June 2026. The court announces decisions on Mondays and Thursdays during June, so we're watching for an announcement on one of those days. The opinion could be short or long. If it's a narrow ruling, just striking down the laws applied to Hemani, the opinion might be 20 pages. If it's a broad ruling invalidating the entire statute, it could be 50 or 60 pages with multiple concurrences and dissents. When the opinion is released, gun rights groups will immediately analyze it. They'll tell people what it means, and gun owners will start making decisions. Do I answer the drug question on Form 4473 differently now? Do I keep guns I was planning to get rid of? Do I challenge my own conviction under 922G3? Now let's talk about what happens if the court upholds the law. If they say 922G3 is constitutional, that's bad news for gun owners who use drugs. The law stays in effect. The circuit split is resolved in favor of the government, and states with legal marijuana will have to accept that their residents can't have guns if they use weed. Gun rights groups will go back to challenging the law in other ways. Maybe they'll argue it's unconstitutionally vague. Maybe they'll challenge the ATF's enforcement, but the core prohibition would stand, and millions of Americans would remain prohibited persons. But I don't think that's what's going to happen. Based on the oral arguments, the government is losing. The justices were tough on the Solicitor General. They were sympathetic to Hemani's lawyer. All the signals point to a win for gun rights. Let me give you one more scenario. Imagine a guy named Tom. Tom is a federal prosecutor. His office has been building cases against people who violated 922G3. They have defendants lined up, ready for trial. Tom hears about the Hemani oral arguments. He reads the transcript. He realizes the Supreme Court is probably going to strike down the law. Tom has a decision to make. Does he keep prosecuting these cases, knowing they'll probably be overturned? Or does he dismiss them now and save everyone time? Tom decides to wait for the Supreme Court's decision. If the law is struck down, he'll dismiss the cases. If it's upheld, he'll proceed. That's the limbo prosecutors are in right now. They're waiting to see if the law they've been enforcing is even constitutional. Now let's talk about the political reaction. Gun control groups are furious about the oral arguments. They put out statements saying the court is ignoring public safety. They're saying drug users with guns is a recipe for disaster. But gun rights groups are celebrating. They're saying the court is finally applying the Second Amendment correctly. The Constitution protects everyone, even people who make bad choices. And using drugs doesn't make you a non-person. The divide is stark, and it reflects the broader divide on guns in America. Look, I spend hours every week watching oral arguments, reading transcripts, and analyzing Supreme Court decisions so you understand what's happening in real time. The least you can do is subscribe to make sure you never miss the analysis when the Hemani decision drops in June. Subscribe right now. And if you found this helpful, share it with every gun owner who uses marijuana or other drugs. They need to know their rights might be restored. Spread the word. Remember, this is educational information based on Supreme Court oral arguments in United States versus Hemani. It is not legal advice for your specific situation. The law is still in effect. The court hasn't ruled yet. Do not violate 922G3 based on oral arguments. Wait for the actual decision. Always consult with a criminal defense attorney if you're facing charges or considering conduct that might violate federal law. Stay informed. Watch for the decision in June, and understand that this ruling could change everything for millions of Americans. This is one of the most important Second Amendment cases in years. And based on the oral arguments, gun rights are about to win big.